Among legal teams I work with, most attorneys sit at one of two extremes, either avoiding AI entirely or jumping in too quickly and risking confidentiality. So I'm giving you my 5-step starter checklist to build AI skills the right way, safely, ethically, and without wasting your time. And the ones who succeed aren't trying to turn into AI experts overnight. They focus on a handful of core habits. The thing is, AI is not going away. Lawyers who build these skills now are increasing their capacity every week and becoming more valuable to their clients, while everybody else is playing catch-up. I'm Ro, founder of MPL Legal Tech Advisors. We work with legal teams to set the foundation for safe, practical AI adoption without risking your client's trust. Before we get to the practical part, let's clear up a few myths I hear from attorneys all the time. Because once those are out of the way, the 5 practical steps are gonna make much more sense. Myth number 1 is AI is too risky for lawyers. Well, the real risk is using AI without any framework, while your competitors are signing more clients every week. Myth number 2 is AI will replace lawyers. I'm not gonna there's a video I did on that, I'm linking it below. And AI replaces tasks and not judgment. You're still in the driver's seat. And myth number 3 is free tools are okay for client use. If you redact every single piece of sensitive information, of personally identifiable information, because free translates to your client data is training somebody else's AI. And that translates to your client privilege is gone. Let's jump to the practical part. Step number 1 is learn the basics and set your own guardrails. And that's before you touch any single AI tool. So here's why. Most of the risk lawyers face is not in using AI, it's in using it blindly. Modern AI, generative AI, is a pattern engine and not a judgment engine. It can draft a memo in seconds, but it doesn't know the law, and it will confidently make things up if you don't guide it, because it cannot do what lawyers do. So take a few hours this weekend to understand what AI is good at, like summarizing, drafting, brainstorming, and what it is not good at, like giving final legal advice or guaranteeing accuracy of what is said. And then set a few red lines for yourself. For example, no privileged or client information into public AI tools, no final filings or client advice without human review, and stick to tools that have clear privacy terms or enterprise controls. Even if you're a 3-person law firm, write this down somewhere. A simple 1-page AI use policy will stop the mistakes before they happen. And it also keeps you safe under your ethical duty of competence. Now, if you don't have time to look into this yourself, this is exactly what we do at MPL Legal Tech Advisors. Book your free consultation call below. Step 2 is identifying the right tasks for AI. For this section, I checked what most AI for lawyers lists recommend, and it's terrible. You can use AI for summarizing 50-page contracts, you can let it run discovery, you can use it for tracking regulatory updates. This is crazy. Just don't. All of these require deterministic, auditable workflows or specialized platforms, and not chatbots. Imagine it gets it wrong. A language model doesn't know, it predicts. It doesn't understand the law or the implications behind the clauses, like your experience does. It cannot replace situational judgment. An AI summary of a 50-page contract will miss material nuance, and worse, it actually trains you to depend on an imperfect tool. Start where risk is low and review is easy. We have timekeeping, AI running in the background, capturing all the hours that you're forgetting to log throughout the month. Email triage into labels and action items. No auto-sending or replying to clients. Template fill helpers that drop your notes into standard letters. Document formatting like TOCs, headings, numbering. I'm gonna zoom out into a bit more comprehensive list here so you can take a screenshot, or you can wait till the end because I have a little surprise for you. Step 3 is to pick one tool and run your own 30-day pilot. Now, keep it small and safe. So how to go about it is check your previous step 2 list of safe AI tasks and pick one area. If you want a quick win, admin automation is always a good place to start. Things like drafting follow-up emails, summarizing client meetings, or even auto-filing your time entries. You can use tools like meeting note takers, email assistants, or practice management software with built-in AI features, such as Clio, Filevine, or even Microsoft Copilot if your firm already has it. The key is to treat this as an experiment. Document how you are using the tool, track the time that it saves you, and at the end of 30 days, decide whether it's worth expanding or keeping. This keeps you from tool hopping and actually shows you the value before you commit to anything. Because those subscriptions, they add up. Step 4 is you need to verify everything. If you use AI for intern level work, then treat it as an intern. The rule should be that nothing AI produces leaves your desk unchecked. So do 3 checks. Site check, open every case or stat in Westlaw, Lexis, or official resources. Confirm it exists, the quote matches, and the jurisdiction is correct. And that it's current. If you can't verify it and set a time for yourself, it's out. The second check is the fact check. Names, dates, figures, clause numbers against the original documents. If AI references section 5, read section 5. And the last check is the reasoning check. Does the argument actually follow? Any too perfect authority or wording is a red flag. So add your paper trail. 1-line note in every document or matter, verified by initials and then date. This takes minutes and prevents fake citations, bad quotes, and embarrassment. Step 5 is expand slowly, keep your score, and keep learning. After the pilot, keep on adding one new use case at a time. And don't relax the privacy or the verification rules that you've set for yourself the last time. Do the following monthly or quarterly. First, review the results. How much time did it save? How much editing did you do? Any close calls? And decide, keep as it is, expand, or stop. 2. Keep a short log. Note the tool, the task, the date, and that you verified the output. This gives you an audit trail and helps you see the patterns. 3. Update your personal playbook. Write down what AI may and may not touch, prompts that worked, and pitfalls you've seen, so your future use stays inside clear boundaries. 4. Check the current guidance. Scan new bar or regulatory guidance of where consent or disclosures are expected and add them to your standard letters and policies. 5. Keep learning. It's literally a part of your duty of competence. Schedule an online course, join a webinar, join a peer group, or subscribe to my newsletter. So your skills and judgment about when to use AI keep improving. The link is down below. And one more thing. Check for your vendor updates. These keep on popping up. Pay attention. They might put you on the wrong side. All of a sudden, one morning you wake up, there's a new update, and your firm has been put on the wrong side of the attorney-client privilege. So the rules are grow gradually, document what you do, and only scale what proves itself under your criteria and your review. Thanks for sticking to the recap. What we've learned today: how do you upskill yourself as a lawyer in the age of AI? Learn the basics, set your guardrails, start with low-risk admin tasks, pick one tool and run your own personal 30-day pilot, verify everything before it leaves your desk, and expand slowly and keep score. These 5 steps are not magical. They only work if you use them. So grab my checklist below with additional 15 safe start AI tasks. If you want help with this, book your free AI consultation call. The link's down there too. If this helped you, subscribe and let me know down in the comments below if you want to see more of these types of videos in the future. Thanks for watching and see you in the next one.